Ready to take your verdicts and jury selection to the next level? Jury consultant Harry Plotkin and trial lawyer Dan Kramer are your ticket to tipping the scales before trial begins. You're not just picking a jury, you're picking justice. Produced and powered by LawPods.
All right, Harry Plotkin, I see you're wearing, is that salmon or pink? What are we rocking today?
I guess it is salmon, yeah. I'm sure there's a good reason for it.
Very nice, yeah. You know, and Harry, I've noticed for these first few episodes of this wonderful podcast, there's been a lot of ball busting going on, and a lot of it's been directed kind of one way, and it's kind of been missing you. So, you know, we decided that we're going to balance things out and bring in a guest who can really, really come at you. So today we are lucky and fortunate and privileged to be honored with the presence of the great Claire Plotkin, the better half of the jury consulting team of Plotkin and Plotkin. And I just made that up. I don't know if that's your official name. But anyway, Claire Plotkin, how are you doing? It is so great to see you and have you here. And we're actually going to learn some stuff today, Harry, I think.
Finally.
Yeah, finally is right.
I'm so happy to be here. I was very, very jealous when I heard that you two were creating your podcast without me. So now I'm going to try to be a guest as much as possible.
Yeah, absolutely. I can't wait.
You'd be like the Steve Martin of the first season of SNL. Just guesting 15 times, maybe.
I can do all that guesting without any of the work. Sounds good.
That is a great reference, Harry. What, like 1975?
There you go. Yeah.
Was that the first season?
You got it.
I just watched we just saw a great movie Saturday night. It's about the first episode of SNL. It's really good. I recommend it. Like all the actors are just like spot on, playing like Chevy Chase, Belushi, Billy Crystal is great. So
wow.
Yeah.
Very cool.
Yeah. Just some 70s SNL references to start our Claire Plotkin show.
Yeah, sounds good.
All right, Harry. Well, let's kick it off and let's start learning.
Yeah.
Here.
I wanted to talk today about and get Claire's thoughts and Dan, your thoughts too on how you handle what bias is when you talk to the jurors, because, you know, I've seen it a million different ways that plaintiffs get up there and talk about bias. And the reason that's so important is that jurors, when they come into the courtroom, they hear what the case is about. They have very strong feelings about like what bias is. For me, it's not really what bias is, but their thoughts kind of hurt the plaintiff bar, because I think most people come in these days and they think, if it's something that I've had firsthand negative experience with it, you know, if I've had a bad experience with a doctor or a hospital, that means I'm biased. Or if I have strong feelings about the case, you know, I'm like, oh man, this is a corporation being accused of cutting corners on safety, and that makes me mad. Or sexual abuse makes me really mad. That means I'm biased. And so if we don't address it, you know, when we go first, we tend to lose sometimes a lot more jurors to cause than the other side does, because, you know, unfortunately, for whatever reason, people who think like, I don't have a problem with it, like they don't think they're biased. And to me, it's like, you know, if you think that like, sex abuse doesn't bother me, like then that's kind of more of a bias than it bothering you, right? But there's, you know, a million different ways to talk about what bias is for jurors. There's Keith Mitnick's, you know, cherry apple pie judging contest analogy, and there's a million different ones that we've heard. What do you guys think works best? And what do you need to do? It does depend on the kind of case.
Well, before we get there, have you had a juror say, "Oh, sex abuse doesn't bother me"? Have you had a juror actually say that?
You know, I believe it or not, I have. I mean, yeah, I have.
Just it doesn't bother them.
Yeah, I mean, people who
nuts.
say, you know, it's like, you know, I have had people who've kind of said like, no, I can be fair. It doesn't really, I don't get emotional all about it and things like that.
Okay,
And you're like, so I can be super fair, and you're like, that makes you more fair.
But there's not like a pro sex abuse jury pool out there, is there? I hope not.
Well,
probably. I don't even want to know. That's probably a whole different conversation. Go ahead, Claire. Yeah, let's hear it.
Well, I mean, I like how you gave me the very controversial topic, Harry, but I'm happy to take it. I mean, I work with, I would say, often newer lawyers than maybe you do. So I do a lot. I feel like my voir dire help is often a lot of teaching. And I find that the first thing we have to do with something like this is teach lawyers what bias is. Because if they come in thinking jurors are biased, they do that whole dance where they just try to get every juror off for cause, which to me is the most ineffectual voir dire. You know, you've seen it where every question a lawyer asks is just, oh, do you think you can be fair? After any answer a juror gives. And that's not the point of voir dire to me at all. And I don't want to funnel everybody out for cause. And I actually think that in today's society, jurors are so ready to be inflamed that they're actually better for plaintiffs.
Yeah.
So I don't want to do a whole spiel on bias. And if anything, I have talked lawyers out of the cherry pie example. I'm sorry, I'm being so controversial, but I don't believe in it really, unless you're in a really bad venue. But because
we're about to get a
of
bunch of letters from Central Florida, Claire.
because of what Harry said. Because,
No,
well, first of all, I have two things. One, a lot of judges won't give you a ton of cause, right? So that the Keith Mitnick style is to get a ton of cause. So you have to know that right ahead, that if you're not going to get a ton, it's kind of a not really very helpful intro. But also, if, for example, I have I have done, if I have a police excessive force shooting case, generally more jurors would, quote, think they're biased for the plaintiff than for the defense.
Right.
So if I give a whole cherry pie, I'm going to have tons of jurors saying, I hate excessive force cases. This is my cherry pie. I can't be fair. So I agree with Harry.
Well, just playing devil's advocate here, tell me what you think is wrong with, the cherry pie, basically, the apple pie contest thing, you're basically telling jurors, if there's just some issue that rubs you one way or the other, it doesn't mean that you're an unfair person, and you're basically telling people a bias isn't something that means you're unfair. It just means it's something that rubs you the wrong way, something you just sort of disagree with and doesn't sit well with you. And that makes it easier in theory for, you'd hope your badgers to kind of say, yeah, you're right. There's something that rubs me the wrong way. And a lot of times in these cases, it could be damages or money for pain and suffering or suing a doctor or whatever. So tell me why you wouldn't want jurors thinking about bias that way.
Because in something like an excessive force case, I would say, especially in Los Angeles or another very plaintiff-friendly venue, you have more jurors that are angry at potential defense misconduct. And I don't want them thinking that this invalidates them as a juror from the get-go. And when I tell lawyers who are doing voir dire early, I tell them, jurors don't know what they're doing. You don't have career jurors here. They don't know if they can be good or bad or fair jurors. So you define it for them. And I see a lot of very nice people. I think generally plaintiff-leaning jurors are easier walked down the cause route because they are well-meaning and they want to help. So if you very early on empower them that they can be fair, instead of, oh, this is probably something you're not suited for, I think you actually keep more good jurors than you would boot bad jurors.
There's a couple things I actually wrote down that I thought were interesting. You said, Claire, is people are desire almost nowadays to be inflamed. We all do, frankly, in the political world and social media, everything. Like, we want to feel angry, we get quick triggered. But I think feeling inflamed and being biased are two very different things. And Harry and I have talked about this. Conversely, I think people don't want to be, or at least consider themselves biased. They're fine to say, I'm angry and get angry. But I think Harry has a really good way, and I'm sure you both do, on those two different things. And I think that's why it's important, I think, for our listeners, how we figure out, like Harry's saying, how do we differentiate the two in the intro almost? How do we tell people it's okay to feel angry, but we just need to know, do you have any feelings against these type of cases generally? Not that these facts may make you feel angry or inflamed, but that doesn't mean it's a bias. So I'm curious what your thoughts on kind of how to educate the jury who doesn't know these concepts just coming in. They probably do deep down. Most of the jurors know these feelings that they have. It's just, how do we educate them to differentiate the two early on, you think?
I think the key is when you're saying about clarifying for them that, first of all, having strong feelings. Like, for example, if the defendant is a corporation, having strong feelings that when corporations do something wrong, that they should be held accountable, that's not a bias. And I think you tell them outright, they have to hear that outright. And that's like one of the first things we say early on in voir dire and because the truth is there are a lot of jurors who think And I've heard this before. Well, I might get really angry as the case goes on, so perhaps I'm biased. And I'm like, whoa, 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 back that up. If the facts make you angry, you're allowed to get angry.
Well, so let's break that down though, like really for, the attorneys out there, for myself too. Like, what have you seen out there as the most effective way an attorney gets up there? Say mini openings done, the judge is done his or her questioning, attorney gets up. What have you seen as the most effective way to educate this? Like, really, how do they say it that you've seen?
Yeah, I mean, for me, and I think what Claire was saying is, which I agree with 100%, it does depend on the facts of the case.
Yeah. If
you feel like you are facing your issues in your case, you have a lot of issues. We talk about meth all the time on this podcast. It's, I don't know why it's not the title of our, it's always our example. We throw out plaintiff on meth.
Picking meth.
Alcohol use.
Yeah.
Drunk driver.
Drunk pedestrian. I think we only had 2 or 3 of those cases this year. Right, Claire? Drunk pedestrian, whatever, something big that you're like, okay, there's a big elephant in the room and we're going to probably need to get a lot of cause on it. And in those cases, then you might want to frame bias a little bit differently for jurors, and maybe the cherry pie, or maybe something that does convince them. If there's something that really just bothers their conscience, and maybe you can't be fair because but if you have a case where it's really the defendant's conduct, and we're talking about just basically think about like what the jurors are hearing the case is about. Like by the time jury selection starts, they're going to hear just a little bit, this is a company being accused of whatever. In those cases, I mean, what we teach is prehabbing, which is basically to convince jurors that having a conscience is very different than having a bias. And the difference is having a conscience is getting upset at wrongdoing that you see in the world. And you can be specific with it about your case. If it makes you upset when teachers, schools turn a blind eye on, sexual abuse, or when, being upset that corporations cut corners on safety or, commit financial fraud, things like that. Like that's a conscience. That's not a bias. And so it's really important when you have a good case with good facts and you're thinking there's going to be a lot of good jurors, and probably the defense is thinking every anti-corporate person or every parent who's got young kids who love kids or preschool teachers, like we're going to get them all for cause. Like you put those on your checklist and you're like, how do I protect those people? And so really it's like, the way that I like to write those questions is to get up there and say, one of my first worries is that sometimes jurors get confused about the difference between having a conscience and being biased. And you explain the difference to them. And
how do you explain the difference?
It's kind of what I already said, but go on, Harry.
It's basically saying one thing that, and I like to ask them, like, when you heard what this trial is about, how many of you started to think you might be biased because of your feelings about, blah, 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 whatever it is, like, negative feelings with landlords or negative feelings with employers or negative feelings about corporations. And so you basically have to tell them, jurors allowed to get angry at the evidence. That's just having a conscience. Having a bias would be, I don't even care what they do. I just hate corporations, even if they don't do anything wrong. And you tell them, to be a fair juror, all you have to do is judge this company, hold them in judgment based on what they actually did.
This particular company. Yeah, exactly.
Right. And some of the keys to telling them that we write is like, you ask them, if you have somebody who's really pissed off, or, you say, does that basically mean that you feel like bad companies should be held accountable? And they say, damn right. And you say, that's exactly what the law asks jurors to do. So it's fine to feel that way. But the key is then you turn it around and you say, now, if the evidence convinces you, here's the key question. If the evidence convinces you that this company or this employer or whoever it is, this driver, did absolutely nothing wrong, do they have any reason to be worried about you as a juror? Because, if you're still going to find against them, that's bias. But if you're saying, no, if they didn't do anything wrong, I'm not going to, they have no reason to worry, that's just having a conscience. And that's really the question that really, I think, where it hits home for jurors, where they get it. But unless you explain that to them, a lot of jurors just don't get it. They think like, I'm biased. Like I come in angry about, companies or whatever. And you're like, well, but are you angry only at the bad companies or just companies in general? Yeah.
I would add in corporate cases, and especially in like employment, because employment is a huge issue. People being really inflamed by employers. I like to add the line, you're not required to come in here trusting and loving employers or trusting and loving corporations. And I think that makes a big difference. And then for like a police case, I have added the line, and it's a little bit inflammatory, but I think it works. Can you imagine if we only seated a group of jurors who aren't bothered by police misconduct?
Yeah, I like that.
Yeah, you could ask them that. I mean, I've asked them that a couple of times. Yeah, do you think that somebody who feels the opposite of you, someone who says, I'm not upset at all, when companies do bad things. Do you think that that's not a bias? And then
Yeah,
sometimes the
exactly.
jurors will think about it and they'll go, I mean, that kind of is a bias.
And this is super, super important in sex abuse cases, because you have tons and tons of either victims, victim advocates, people who just hear about like a little kid being abused and they're so upset. And you have to say, like, it's okay to get angry at sex abuse. This will be hard for everybody here. You know, what you
Except
have to
the guys
see
who are,
is
except those two guys who are not bothered by it. When, you know.
right. What you have to do is see, and especially if it's like a sex abuse against a school district, what you have to do is see if this school district is responsible for this abuse, you know, and it's really much easier to compartmentalize it for them in their mind.
So a lot of the cases you're talking about is obviously you're protecting the good jurors. Clearly, you know,
Yes.
you want to
and empowering them. I
and
think
empowering,
too.
yeah, sure.
Yeah.
But you're insulating them from a defense getting up there and getting a cause challenge on them.
And just knocking them
yeah,
off.
you've prehabbed them. But in those type of cases, you know, corporate defendant, those cases that we all love to have. But what about in the meat and potatoes cases where, you know, it's a grandmother rear-ended the plaintiff, you know, plaintiff took a couple days, went to the ER, went to the urgent care, you know, worked up, had spine surgery. You know, ultimately you're asked for millions of dollars, but you know, cases that I've tried with both of you, frankly.
That's true. I mean, maybe the cherry pie example does work better for those when you know, especially if you're in a venue like maybe Van Nuys,
San Mateo, or
are a little bit more apprehensive about accident cases in the first place. That's true. If you know that you have probably a venue where you need more cause, please use it. But if it's a kind of case where the jurors tilt towards you, I would be really nervous.
I think that's the key lesson, though.
Yeah.
I think this is super important for our listeners. This is why I think the stuff Keith Mythics has done is great. It's kind of revolutionary. Like, I've used it a lot. I love his books. But this is why it's important that trial lawyering is an art, right? You can't just scientifically use every single type of thing that you we read from these books and picking a jury, you know. And I think that's 100% the case selection.
Yeah, it depends on the case. You got to have all these tools available depending on the case, and figure out when do I employ this, when do I employ that.
Or when do you introduce these concepts?
Okay, I was just going to get on my soapbox for a second. That voir dire is not just a conversation where all you're doing is trying to get cause. I really want to encourage lawyers to really think about what their objectives are for voir dire, and because there should be learning about jurors too. And so if you ask questions that are just weird, open and shut, yes or no, to try to see if they hate lawsuits or not, and then just railroad them all for cause, first of all, you're probably losing good people. Second of all, you don't know anything besides that very, very specific black or white issue that you asked about. And you're probably missing a bunch of people in the middle who are probably nuanced jurors who are going to stay on your jury and make the decisions, right? And I see it all the time because lawyers are so indoctrinated now that cause is king and this is all you do, where like literally they say, hello, how are you? And the person says, hi. And then they're like, do you think you can be fair? Like, it's the first thing they do. And it also gives you a really bad rapport with the jury, I think, if it looks like all you want to do is shove them off the jury.
I mean, this has been one of our mantras, I think, since we started this podcast, is because from my personal experience with like one of the first few times I used Harry was the same thing. I was like, came from that school of thought where it's like, I'm going to get 15, 17, 25 cause challenges. I'm just going to rack up my stats and then I'm going to have the best verdict ever. But that is just not at all true.
I mean, yeah, if you have a good case and you're a good lawyer and you're in a pretty good venue, you don't need as much cause as you probably think. If you have a really just case, I mean, it's like you don't need tons and tons of cause. But sometimes you do. Like we talked about, you know, meth and alcohol, and you know, there's issues that come up where you're like, okay, I need to pull that out of the belt. I need to grease the wheels and convince everybody that, you know, most people are maybe biased in this case. But what we're talking about here, though, really is framing, you know, and lawyers know, I mean, I think most trial lawyers now know how to use framing for cases, and they understand it's different for every case. Like, you know, if you have a case where you represent somebody who got rear-ended, you're going to frame it one way. But if you're the person who did the rear-ending because somebody hit their brakes all of a sudden, you're going to frame it totally differently. You know, like one way you're going to be like, you got to watch out for, you know, what's ahead of you. And the other way you're like, you know, if you're the person who did it, you know, you're like, you know, drivers have a right to expect people are not going to suddenly stop. Totally opposite framing, right? Same, but lawyers don't think often about how do I frame bias for jurors, and that's what you're doing, or you should be doing. Most lawyers don't really do it, but you have to think about like, how's the best way I need to frame for the jurors what bias is in voir dire from the beginning. And really, what we're talking about is the way that we frame it with prehabbing is like, bias is something where it doesn't really matter what the evidence shows, right? Like if you just sit there thinking like, I don't care what's, Mr. Kramer, I don't care what you got in evidence, what the witnesses are going to say, you're never going to get $10 million. Like that's a bias because it doesn't matter. But if you're sitting there, if you're a conscientious juror and you're like, I really hate companies, I really distrust them. But if you can convince them, but does it matter to you what they did in this case? If that matters, if the evidence matters, that's not a bias. That's just judging them on the evidence, and you're allowed to judge. You're allowed to sit in judgment of these companies. You're allowed to get pissed off.
I will tell you, I have seen lawyers attempt prehabbing and give up like a minute or two in because one juror doesn't get prehabbed, right? Like, let's just say I've seen it before in downtown. I've had a juror say, I could never award a verdict against a plaintiff I feel like that's being for a corporation, and I could never be for a corporation. So it doesn't matter what the facts are. I will never side with the corporation. And you know what? So what? Shake it off, move on. That person also seems a little extreme and strange to the rest of the jurors. So if anything, they did you kind of a favor.
Yeah.
Because most jurors don't feel that way. When you do prehab, you have to be thoughtful, though, to not just completely point out all your good jurors. I've seen lawyers do it a little bit badly where they say, who here hates corporations? And then picks on each one of them. And instead, you kind of did some work for the defense. So I like to make it a little bit more like talking to the group and not picking on people until they've heard the spiel.
So,
because, yeah.
Yeah, no, I mean, I think that's a great example. Let's play off that for a second. So you have a juror that says that, I could never award, I don't care, I hate corporations, they should all pay, I don't care if they're good, bad, ugly, the best, whatever. I would tell me if this is not correct, but say, thank you for that. And maybe this isn't, that may be a bias. Maybe this isn't the right case for you and all that. Maybe you're not able to be 100% neutral for the defense. Now, let me ask, is everyone else, are you willing to listen to the evidence and see what the evidence is going to show? Or, is everyone else able to do that and kind of, not judge this corporation yet, but is everyone else able to listen to the evidence? I don't know. I would pivot that way. And then you've kind of prehabbed the rest of the panel, right? Because no one else has raised their hand. I don't know. How would you guys handle it?
You don't argue with that juror. I mean, you're going to get that. And I always tell people, when you're prehabbing jurors, you're not going to bat 1,000. Right. That's fine. You're not. Some cases you're going to bat. I mean, I had one trial where with David D. Robertis a couple of years ago where we batted almost like maybe 100. Like we got like 90% of the jurors who had negative feelings, like we couldn't prehab them. That was the biggest verdict I've ever gotten in my career. Yeah. Because, and one of the things that happens is that, when you're prehabbing, as long as you're making these points to the rest of the jurors are listening. And I think a lot of the other ones who may normally say, I'm kind of biased too, they kind of like lower,
exactly.
They don't even speak up. They're like, oh, okay, I'm not biased, so I have nothing to tell the defense. And then the defense cuts up there and asks them, like, any issues with you about corporations? And they go, I'm going to judge you based on the evidence, and it's kind of what, you kind of hear them saying what you were just kind of saying. And then, okay, this person wants to judge, and wanting to judge a corporation, being like, I'm ready, that's a good thing. But defense lawyers often think that's great.
I will agree with you in that case in particular. And there are some corporations or particular defendants where they just are going to be more difficult to prehab. I can think of one in particular where prehab really didn't work and the lawyer kind of gave up was LAUSD.
That's LA school district, just for...
Yeah, which just has a very bad reputation. So I had tons of jurors who don't even have kids in the district, but who just already thought that LAUSD stinks. And they were convinced that they were biased. But that was a very unique situation. And it gave me a lot of insight into how to properly prehab when there's a particular company that kind of everybody already dislikes. And you with Southern California Edison, you had the same thing. Correct.
That's not very fair to them that you mentioned them. Poor Edison.
Yeah.
Poor LAUSD. We may have to cut that out there.
Yeah. Let me say, when Dan, your example, you handle that perfectly and you don't argue with that juror who's like, well, there's no way you just go, yeah, exactly. You go, that wouldn't be right for you to be on that jury. That's one thing that, Nick Rowley does amazingly. If someone says something, he doesn't argue with them like that. He goes, it wouldn't be right for me to have you on this jury. Okay, if I ask the judge to excuse you and everything. But then you pivot to everybody else. One thing though that I worry about is then sometimes other jurors will say, well, I can listen to the evidence and I can judge them based on the evidence, but I still don't think I can be fair because, things I've heard about LAUSD or feelings that I have about corporations or whatever, I'm pretty sure that they did something wrong. I just have this fundamental distrust of corporations. So I'll listen to the evidence, but I'm way ahead. And one thing that I've been doing lately that you got to be ready to do, I think, is to say, everyone's used, like, I'm sure you all are familiar with the starting line analogy where you go, we're supposed to be the same spot on the starting line. No one's supposed to be ahead or behind. And that's fine if you feel like, but let me ask you this. Are you telling me that the defense is behind already, having not heard anything that they did? Or are you telling me we're at the same starting line, but you're just sort of guessing that they're going to lose this race? Because guessing is, that's not a bias. That's just a thought you have. But if you can start us on the same starting line, once the evidence comes in, they're ahead or behind based on the evidence. And a lot of times that framing gets jurors to go, I guess you're right. I think you're telling me that you think they probably did something wrong, but if they didn't, does that mean we're still going to win? And they'll usually tell you, well, no, of course not. So you're like, so we're not really ahead. You're just guessing, right?
Just real quick on that. I just want to play devil's advocate a little bit because sometimes you do ask questions like, has anyone already prejudged this case? Or, based on the mini opening, anyone kind of already just what you heard? I just don't think I could be a neutral juror in this case. I mean, isn't that kind of what you're asking them not to do by guessing what's going forward a little bit?
Well,
you're asking them not to, but Claire, go ahead.
I was just going to say, ideally, if you've done your mini opening right, you haven't given them enough information about the defendant for them to properly prejudge. Ideally, they know so little that if you give them enough facts in your mini opening, then they will prejudge, and then you're kind of screwed. But if you say you're going to find out what their conduct was, then they don't know. And so it's much harder for them to say, I'm already against them.
But sometimes they'll say, right, I just really don't like, I just feel like too many landlords are unethical or too many these companies are unethical.
Landlords are hard.
So even though I listen to the evidence, I feel like I'm not 100% neutral because I kind of feel like they probably did something wrong. And if you get them there, that's where you kind of say, are we really ahead or are you just sort of guessing? It's kind of like, I hate using sports analogies, but it's just where my head goes. It's kind of like a referee thinking like, hey, I'm about to referee the best team in some sport against the worst team. Like you'd be guessing they're going to win, but are you going to judge it based on how many shots go in the basket and what the final score is? Yeah, then you can be a fair referee, right?
Exactly.
I mean, you're going to, of course, a referee is probably thinking, I think the Bulls and Michael Jordan are going to win tonight against the worst team in the league. But, that's not the same. So if you kind of use that framework, because a lot of jurors do think that. They think like, I would probably think that you're going to win is not the same as a bias. That's just sort of as long as you can say, can you have the integrity to judge them fairly and judge them? And fairly doesn't mean in their favor. Fairly just means get upset if they did something wrong and don't if they didn't.
I mean, frankly, you can even bring it back to parenting. If one of your kids has done something bad, are you going to automatically assume that was them again? Or are you going to look at the facts and see which one is correct?
Yeah, no, I actually like that. Yeah, if your two kids come to you, say, oh, my daughter's saying my son Joey hit me, I don't know. Maybe that's not the best, but I like it.
But it's
There's
true.
a better way to
say
say
it. But are you going to hold it against them because I did one bad thing in the past? Or are you going to have to, is it your job to give both a fair assessment and see who really did it?
Yeah, no, I like that a lot. But I really do want to hear from both of you. Just put it out how like you get up, the attorney gets up, does an intro, I assume. You guys, their names, all that. You like that, so okay. And then do you like for the attorneys or what you've seen is really effective to talk about kind of brutal honesty, introduce that concept, and then introduce biases? I mean, I really want to hear exactly what you think is the most effective way kind of out of the gate.
So I want to answer this because you had said something earlier about alcohol or meth or something, and me using talking about biases because you're worried about getting those people off. So if you don't mind me referring to a particular case, if that's okay. We did one where there was it was a drunk pedestrian in the middle of the street, and he was drunk and using marijuana. And it was against the CHP. So I felt like there was potential biases on both ends, but I actually felt like the CHP's feelings were probably better for us. So we didn't do anything about cherry pie or anything. We just talked about brutal honesty, the importance of having real conversations, being brutally honest, not hurting the lawyer's feelings. And I think the way to get them off with regards to like the alcohol and marijuana without having to say, is this your cherry pie or whatever, is I like to ask, are your feelings about marijuana or alcohol or drugs so strong that you can't, that's it for you. Like you already feel like this plaintiff is 100% at fault, or you already have given them fault because of just that usage alone. Because I think that is one of those things where people have such strong feelings that it kind of does it a little bit for you just because of the substance itself.
Okay, but now I'm going to ask you though, in a case where like the cases that many people attorneys are trying all the time out there, the car crash case, the whatever it is that we all try. What do you see is that so
brutal honesty for sure.
Brutal honesty, okay, and then how do you like to see the biases there?
I think in these cases, like in a car crash case where it's against an individual and not a company, and so therefore, other than maybe sympathetic jurors who feel a lot of sympathy, you're probably going to not have to prehab as many jurors. You're not going to get as many jurors thinking like, oh, I'm already biased for the plaintiff. I
love seeing 80-year-old women get $10 million judgments against them.
Right. So for me, I think
gotta teach them a lesson.
Yeah. So you think about the frame, like, okay, what kind of jurors is the defense kind of get off that I think are probably can be perfectly fair just because they're sympathetic and they value quality of life and they think that drivers should be held accountable. I mean, those aren't biased jurors, but who are the jurors how do I frame bias in a way that I can convince the bad jurors for me that they really can't be fair? And for me, it's like the same framework of anything that, you can judge the evidence. If you're just judging the evidence, if you're going to have strong feelings about the evidence, that's not a bias. But if you're worried and concerned about things that are outside of the evidence, that's a bias. And so that's why we talk about, things like, who's going to pay, and you tell them like, Dan, we've done this a million times in these kind of cases where you basically say the court is going to, you're not going to hear any evidence because the court is going to tell you that's not at all relevant about who would pay this verdict, how it would be paid. And so, well,
I like
so
when you throw the question back. I like when they're hesitant and you throw do you know how it's going to be paid?
Right.
I like that.
Right. But at the end of the day, you're telling them, so as much as I wish we could share everything with you about this case, we're not allowed to, and you're not going to hear it. And so, but the court's going to tell you that, but I know you're human beings here. And so, and I'm guessing some of you may feel like that is important to me. And I'm going to always that's going to be in the back of my mind, especially if I have to come up with a number, and especially if the number they're asking for is a really big number, that's going to be weighing on me. And then you tell them, who kind of feels that way. And then the way that you frame bias to get off for cause is to say, just like under the law, it's just not something you're going to hear and not something that you're supposed to matter. And so that, that's essentially that is a bias. If that's something, and there's nothing wrong with feeling that way, but if that's just going to be in the back of your mind and you're going to be worried about whether you think that a guess or an assumption about the defendant paying it, that's something where you can't be totally neutral when it comes to what the law says. And so then you're framing it around like considering stuff that is not relevant, or no matter what the evidence shows you, I just couldn't give a huge verdict because I'm thinking about something else outside. So as long as you're framing it that way, and so that's a choice. Like, you're framing anything in the case, the evidence is fair game. Everything outside of the evidence, if that's going to be stuck in the back of your mind, it's not.
And remember, I would encourage you to listen if your judge does voir dire. I would encourage you to listen to how the judge frames bias as well, because I think it really helps you. It gives you like a roadmap for, first of all, how you're going to get cause. But second of all, what you might have to sort of preempt if the judge is kind of willing to let people go, it seems early on from their own question. Prehabbing is much harder if the judge does a lot of extensive voir dire on their own and already has decided that certain jurors are biased. It is harder that way.
All right. So want to thank our sponsors again. The first one is Verdict Videos. Kelly Deutsch. If you don't know Kelly Deutsch and Verdict Videos, welcome to the Plaintiff Bar. I know that, for Dan and myself, we work a lot of the same cases. I know for my wife and I, we have focus grouped their videos in focus groups, and jurors have loved what they've seen of these things. I've seen the increase in value, and the settlement value of these cases is sometimes tens of millions of dollars more after the jurors watch their settlement doc videos or day in the life videos than before they they watch the video. And day in life videos, I don't know if you use them, Dan, but they're not just for trial. Settlement videos for mediation are an effective tool for trying to settle cases pre-lit too. I'm sure you use both of them.
Yeah, I mean, the best thing about working with someone like Kelly is that you're not handed off to some, other person, or you're just dealing with projects. Like you will get Kelly's cell phone. She knows how to talk to clients, and I think that's one of the hardest things when someone's to be invited into their home. She'll talk to the client. She'll sit down with the client. She knows how to tell a story, and she's just such a wonderful person, like truly empathetic, compassionate. She really understands what a client's going through, and that shows through in her production. And she's wonderful. We love her. She's just she contributes to the community. I know through LATLC, the charity, and all that. She's just a great person. Very easy to work with. Great pricing, and really will add a lot of value to your cases.
And I know what a lot of lawyers that I talk to love most about Kelly and Verdict videos is they are always honest about whether they can help or not. I know there's cases where she has said, I don't think I can in this case, but I know that she's told me, our motto is video can hurt you as much as it can help you. And so I know she actually cares and is strategic about how she can help in these cases.
Which is very true. I think in general, like everyone's like, oh, I need to have the best animation. I need to have this, that, and the other thing. Sometimes less is more. And again, it's great. It's important to work with vendors who are going to be straight up with you and who are going to be honest, like Kelly, and not just want your money from the case. Like she will be straight up, and those are the best vendors to work with. Another wonderful sponsor I'd like to thank is my dear friend, Melissa Baldwin from Baldwin Settlements. She is a structured settlement broker. She's fantastic. She's one of the first people I met when I became a plaintiff's lawyer, and has just given back, just great advice. She's another one of these people you can call and just, get some advice, and she'll really go out of the way to help you out. She supports CAOC, CALA, all the, AAJ. She's a huge sponsor of all these organizations. Her and her structure team work tirelessly with the attorneys and clients, and she really makes the hard fought result easy for the client. I mean, I had a very tough case from someone who was basically homeless, and she was able to make him understand he did not have any education to speak of, barely spoke English, but get him to understand how important it was to structure the money, because a lump sum and the many millions of dollars just would not have been good for him, given that, he had some issues with drugs and all that. She was able to speak to him at his level and get him a structure that really set him up for the rest of his life. And she was willing to work day and night, anytime, weekends, just to help get it done and get the best rates she can for the clients. So, and she also does not just structure. I used to think, I'd be like, look, when I was just starting out, my cases aren't big enough for you, Melissa. She's like, no. Like it's not just for the 7-8 figure settlements. It's really for all clients who just need some help to structure. And she can also structure fees, which is great if you want to put a little bit away for yourself and your family later on. So call Melissa Baldwin from Baldwin Settlements. Really great person, great friend. These two sponsors are just wonderful women that I really respect, and they run great businesses and good people. And lastly, we just again want to thank Law Pods for making this possible. These podcasts, their whole library of attorney podcasts truly help, all of us get better. And I highly recommend you just listen to them. I put them on the car. I'm listening to all these trial lawyers throughout the country with all the experiences they have. And it's just such a great avenue, because we can't make it to courtrooms all the time, but we're hearing from the best. So thank you for Law Pods for providing that platform. Talking about framing biases, but Harry, I still want to get, how do you like it when the attorneys introduce the concept of bias? I know we've talked about it, but like, what is the wording that you like? How do you like your attorneys to say it?
Well, remember, it depends on how you're framing,
car crash
how you
case,
want to frame it. So that kind of case, yeah. In a car crash case, I would just, I wouldn't necessarily prehab them and talk about feelings about, because you're not talking about feelings about companies or strong feelings about the subject matter of a case. I think in that case, you do kind of want to use more of the negative. I say negative, but kind of like, hey, and anything that bothers you about this case, it kind of is a bias. It's going to be weighing on the back of your mind. So, the way I would say it is, one of the things I would talk about is who's paying. That's a big one. And we talked about, you're going to be hearing about this case, and we're going to be asking for a lot of money in this case. And so I just want to make sure that everybody is comfortable enforcing the laws in this case. And it wouldn't be right. I think we talked about this on the podcast with Steve Vardazarian, but it wouldn't be right the way I like to say it is, you're going to be asked to enforce the law as a juror. And it wouldn't be right to ask any jurors to enforce a law that doesn't really sit right with them in the first place. That's really hard to do and unfair of us to ask you. And so I need to talk to you. Is it okay if I talk to you about some of the laws in this case that are going to apply to this case? And then that's when you go into different things, and depends on the case. Like in an employment case, I usually will talk about one or two things. It might be if it's against a company, FedEx driver hits somebody, I might have the lawyers talk about vicarious liability, because some people feel like, why is it's not fair for the company to get sued for some stupid driver who was trained properly to speed or run a red light. If it's a case where, it's an employment case, sometimes it's something like
constructive termination.
Yeah, constructive termination or accommodation laws, or, some people don't feel like a company shouldn't have to hold someone's job if they're, if they need a medical leave of like 18 months. I mean, some of them are like, that's a pain in the butt and a nightmare. And I don't think that's right. But in a kind of a standard, auto case, some people feel like, it's just like these kind of lawsuits rub me the wrong way, no matter what the evidence is, or big damages rub me the wrong way, or why should a person, sometimes it's like, if it's just an accident, it wasn't intentional or whatever it is. So I like to go through, just pick a couple of things to kind of exclude jurors who are going to be rubbed the wrong way by some of the laws. And obviously a big one in that is compensation for pain and suffering and things like that. That's a big one. But
I think what Dan was wondering, I think, is do you suggest in your intro that you do like a metaphor, like a warming up kind of thing,
right,
like the cherry pie? And I don't
That's what I'm trying to get, Claire.
I don't necessarily do that. I mean,
yeah, I don't love them. I mean, I think judges, some judges don't like you to go for too long without asking a question, and they bark at you, and where's the question in there? And sometimes, so I like to keep it like, that's all I like to keep it short and just say, there's going to be this jury is going to be asked to enforce some laws that are important, and so I just want to make sure you're comfortable or uncomfortable, kind of the thing that I just talked about. It wouldn't be right for us to ask a juror who disagrees and doesn't make you an unfair person, but it's okay to feel like a law doesn't seem right to you. And make sure to tell them, the important thing is, don't ever tell them, that you can't be fair. And the other thing I never want to tell a juror is tell them like, follow, can you not follow that law? Because jurors don't want to say they can't follow a law. It makes them sound like a lawbreaker. And jurors are not following laws, they're enforcing laws. Like a juror who, is not like breaking a law. I mean, they're just like, if you don't agree with, sometimes I'll use the analogy of like, if you don't agree that there should be speed limits, would it be fair to make that person be a CHP officer and write tickets all day? I mean, they're probably just going to you're going to be like, I'll let that one go. I'll let that one go. Right. So that's kind of the only analogy that I use. And then I think you get into some of the things and say, does anyone here feel like that's money for pain and suffering beyond, the bills, the financial bills? It has no purpose other than to compensate. Some people feel like that's unnecessary or pointless or greedy. Who kind of feels that way? And then you bring it back to but the way that you frame it is you bring it back to, well, that's a law. That's what the law is. Is that something that you would struggle to enforce? And that way they're kind of outside the box now. They're kind of making decisions outside of the law. So you're framing bias as like, okay to feel that way, but you're not really agreeing with what the law tells you.
Yeah, I also think with all this great education in the last 20 years that the plaintiffs bar has, all the great books, the David Balls, the Mitnicks, all these rallies and these, podcasts like this one, hopefully, is that, a lot of new attorneys think they have to do it this way. They give all the same analogies. And what I've started to find, judges are starting to get kind of annoyed with them because they hear them all the time. I mean, Harry, we tried that employment case in San Bernardino, and the judge is like, please do not say the words brutal honesty again. I've heard that so many fucking times. Like, don't stop saying the words brutal honesty. But I still did it, and it's fine. I think it's important to talk about brutal honesty, but I've heard judges say, not the cherry pie thing. We're not going to talk about that. It's become almost overused because it's not unique to the person. And I also do think you both are right. There's a quick, efficient way that we've talked to Ricardo about, Steve Artezeri, and it's just like, look, bias is not a bad word. Our goal here is just to sit a 100% neutral jury on for this type of case. And so we just need to ask you some questions to find out, maybe you're leaning one side or the other, and that doesn't mean you're unfair or you're, whatever, prejudiced person or anything. We just need to find out if you're going to be 100% neutral in this type of case, right? And then you kind of can go from there without doing a whole long thing, because the judges are shutting that down, I think, more and more.
I would tell you too, this is a small thing, but I don't like it when lawyers make like a quip when there's somebody who is clearly biased. Like, for example, that person who said, it doesn't matter what a corporation has done, I'm never going to side with a corporation, I've seen attorneys say, "Oh, you're my dream juror. I would love to have you." I don't think that's helpful either. I understand that they think it's funny, but that defeats the purpose of what you're trying to do too. You don't want
That's a really good point, Claire.
You don't want the
I
rest of
think.
the jurors to hear you say that you want somebody who doesn't even need one shred of evidence. How insane is that?
Because you should want justice. I mean, you do.
Yeah.
You want a fair fight is what you want. So if you want that juror, that means you want to stack the deck, and that's an unfair
it
thing.
makes no sense.
And you lose credibility, even though you may get a chuckle. Try to ingratiate, but why even try to ingratiate yourself to that juror anyway?
Yeah.
He's going to be gone and not even on your panel. So
No, thank them.
That's a really important point.
On. Yeah.
No, those little things that we say that we think are kind of flippant or I don't know, they're not just kind of casual. It's going to sit in the back of certain people's minds. I think that's an important point. I'm guilty of it. I'm sure I've done it more than one time. I mean, multiple times, but it does kind of give off the impression,
It's actually kind of another small soapbox of mine because I've seen. Can you have a small soapbox? I don't know.
Go for it.
Because I've seen it a lot in the past year. Voir dire is about building rapport, building credibility, but you really should not be going for entertainment value over information. I honestly would prefer a 90% boring voir dire where I can get information than one where the jurors are laughing at your jokes and you think they're all on your side, because I have seen jurors laugh at the lawyer, love them, and defense them. I have seen it so often because you went for the low-hanging fruit and not their actual experience, their expectations, all of those things. So I would encourage you to do less of the joking and more of the effective voir dire.
Harry, jokes or no jokes? What's your stance?
I mean, be yourself. Jokes are okay.
But you agree with
as long as they're not.
Information is king.
Jokes are not a substitute for assessing your jurors. Yeah, for sure. But I mean, I think it's okay to be a little funny when the opportunity is there. I mean,
for sure,
that's okay.
But it can't be the only thing.
Yeah. And showing jurors, I mean, I think it is really important to show jurors that you're a human being and you can make them laugh a little bit, and you can take, if somebody tells you a really sad story about, gosh, well, my uncle was in a car crash, killed by a drunk driver. You're not just like, okay, well, does that mean, you're just like, take a step back and be a human being first and go, oh my gosh, like I don't even know what to say. I mean, is that, so you tell me, I mean, is that something that's going to bother you in any way or make you, and so just being a human being is number one, and humanizing yourself is important. But you're right. It's not a substitute it shouldn't be your whole primary purpose of voir dire, for sure.
Well, you can't charm your way to a win in jury selection. You just can't use all your charisma. I mean, yes, you got to be a human being. You want to be personable, listen, and that just comes naturally just listening to people and reflexive listening.
But I bring it up because I do feel like there are a lot of attorneys who see examples of really charismatic lawyers, and then they get very nervous about voir dire because they think, I'm not that. And I just really want to make sure you don't have to be that. If anything, half of that probably works, right? Yeah.
Be yourself. Yeah. Be yourself. And be the best version of yourself. You don't have to be super engaging. You have to be funny, but, bring your personality out a little bit. Be yourself, relax, and be a human being first, and not be, this is not a deposition. Yeah.
But genuineness and earnestness are their own charisma too, right? So if you're not like a comedian, but you're like, you look like somebody who cares so much about your plaintiff and you're trying to do a great job, that comes across wonderfully too.
One thing I want to talk about, though, one thing that I like to frame bias is with sympathy in injury cases.
Yeah.
Really, mostly just injury cases, employment cases, not quite as much,
and molestation type.
Because that's another thing. I mean, when you're prehabbing jurors, what you're really doing is you're putting together a list before jury selection of like, who are the kinds of jurors that the defense is targeting? Like, who right now is the defense counsel thinking, I'm going to get for cause anybody who feels a ton of sympathy, anybody who's had a firsthand or secondhand experience with this, anyone who has a negative feeling about who I represent, or maybe an actual negative experience with it, or just people who feel, and sympathies in a personal injury case, that's high on their list. I mean, Dan, how often have you seen the defense not touch sympathy in voir dire?
Yeah, I mean, I think a lot. I can't remember. Well,
it's shocking when they don't, right? Like, when they always, that's one of their main go-to moves is like, this is going to be a very sympathetic case, and who feels just a ton of sympathy. And you've had a family member that this has happened to them, or, or you just have strong feelings for, for kids or the elderly or whatever. And so I always think it's really important to do some prehabbing and frame what bias is and isn't for sympathy. Because the one thing that I'm sure you guys have seen this a million times, the one trick that the defense bar does is they tell jurors, and jurors believe it unless you've addressed it, that they're not allowed to feel sympathy. That's inappropriate. And they have to leave sympathy. You have to leave sympathy outside the courtroom. And that's impossible for anybody, but they say it. And when they say it, jurors believe it. Like, I can't possibly not feel the sympathy or not, So what I always do is I always tell them, you're all going to feel sympathy. And another worry I have, sometimes jurors think that they feel sympathy, they can't be fair. That's not true. You're allowed to feel sympathy. Everybody is here. That doesn't disqualify you from being a fair juror. You just have to put the proper value on, someone lost, a family lost in a wrongful death case, or the quality of life, someone's quality of life when they've been, seriously injured. Not a dollar too much or a dollar too little. Whatever your judgment says is right. So the way I like to frame it is, you're going to feel sympathy over here, but you also have your judgment. And one thing that I tell them that I think is really important, I don't want to see what you guys think or what other spins you guys like to put on it, but I always tell them, I use this analogy of letting sympathy decide this case would be like putting a much higher value on something than it's really worth. If you were to give $1 million to a cute crying child, adorable kid who's crying over an ice cream cone she dropped, that's ridiculous, right? That's pure sympathy. But, deciding that a value of, for example, a husband or father to his family is incredibly valuable. Deciding that the value of a husband and father to his family, or the value of someone's quality of life is important and incredibly valuable, maybe worth many millions, that's not sympathy if that's what your judgment tells you it's worth. And so you might feel like it's incredibly important or worth many millions, or maybe not as important or worth less. That's totally your call. Can you, make a call on that using your judgment? And so telling them, I think it's really important to say, feeling sympathy does not disqualify you. So don't fall for what the defense is going to say, but having this judgment that these things are valuable, incredibly valuable, that's fine. And so I think you have to that's another thing I feel like I always have to tell jurors, because otherwise they're going to get tricked.
Because the law is, I'm looking at the California jury instructions, all it says is do not let bias, sympathy, prejudice, or public opinion influence your verdict. I don't think there's any case law or any jury instruction out there, I doubt there's in any jurisdiction, that says you cannot feel sympathy.
Yeah.
And I think that's a super important difference, because you're right. The defense attorneys always are like, you sound like a sympathetic person. Maybe you're going to be too sympathetic for this case. I need to do that more, frankly. I need to add that more to my voir dire.
I do
Go
it
ahead,
a little
Claire.
differently, but I think, Harry, I liked your thing, but mine is a basic one that I've done for years, but I think it's very easy for lawyers to do, which is you're allowed, this case might make you sad. This is a wrongful, this person died. You're allowed to feel sympathy, right? You have to very clearly say that. You're allowed to feel sympathy and be a juror in this case. And then I like to say this, it sounds so stupid, but I like to say it. No one is expecting to have a jury of robots listen to this case. You're allowed to be a human with real human feelings and sympathy. And then I say, there are jurors hear murder trials all the time. And people feel sympathetic and angry about murders. And yet, how could they ever find a jury for a murder trial if sympathy excluded you? Right? And kind of reframe it that way. But I do like to say we're not expecting to have a jury of robots. And I think that, because it sounds so silly, but I think people get it. I can't be that person, but you don't have to be.
And especially it makes, I think, the beautiful thing about it, you're setting the defense attorney up for when they start talking about, well, you're sympathetic, it makes them just look like they're also trying to stack the deck, and they also are just kind of looking for robots. The corporation's looking for robots, right? Lit in a way.
Yeah. One time I had a defense attorney, this is so funny, and just preparing you guys for some tricks that might come your way. I've heard him say, you've heard him say this, right, a million times, could you, if the evidence convinces you that, or if they haven't proven their case or convinces you that the defendant isn't responsible, can you, send the plaintiff home with nothing, right? Empty-handed. That's tough to do if you're sympathetic, right? And one time I had them a defense attorney say, could you look the plaintiff in the eye and tell them they get nothing? And we started to get a couple of jurors saying, I don't think I could do that. And I was tugging on the lawyer I was working with and objecting, he's telling them, and they're like, no, you don't have to look them. And the judge heard the objection. They're like, do you understand, juror number 9, that you don't actually have to look them in the eye and tell them? And the juror was like, oh, really? That's what I thought he was asking me to do. Like, I have to deliver the bad news. So, I mean, I've seen that happen where, so objectively say, you have to look them in the eye.
In the same vein, I once had a very interesting, enlightening, it was in Santa Monica, and I feel like you get very enlightening jury selections in Santa Monica because everybody has an opinion. But there was a whole back and forth between where jurors started pushing back. I think you have this wrong. This is not sympathy. This is empathy. I have empathy. And they're like, I think it's perfectly normal and okay for me to have empathy. You can't tell me I can't be an empathetic person. And like jurors were getting mad at him for trying to get people off for sympathy. A woman was like, what are you doing? What are you doing telling me that we can't feel empathetic to somebody who's been injured? That doesn't mean I can't be a fair juror. It was interesting. It like backfired.
That's not a bad idea. I mean, have you thought about maybe framing as the plaintiff attorney to frame it that way to get the jury talking about the difference between sympathy and empathy?
It's an idea. It completely just came from a juror's mouth, but it really hurt that defense lawyer a lot because he got kind of stuck and jurors started pushing back on him because it was so obvious what he was trying to do.
What is the difference between sympathy and empathy?
I think
Come on, Duke grad.
I think empathy is feeling someone's what's happening to them, right? You're feeling for them, but you're not like feeling sad for them.
So yeah, empathy. I just looked it up. Empathy is shown in how much compassion or understanding we can have to give another. Sympathy is more feeling of pity for another.
Yeah, it's feeling it versus understanding how they're feeling, which a lot of jurors would probably say like, what's the difference? It's like.
Well, I think the key is pity, right? I mean, I think when people hear, if sympathy means you feel pity for somebody,
true, yeah.
I think that's a
Right.
difference.
But feeling compassion because somebody has had something bad happen at the end of their life, that's normal.
How can
you can't have those people just get knocked off.
And how can you assess damages without having empathy, without thinking, like, what is this like for this guy? I mean.
Right,
it's not even possible. So
I was going to say, like you said, you have to be like fully aware of what you're up against. And I feel like it's very common to see defense attorneys say, who here is a sympathetic person? And then like pick on them. So you have to hit it first because it's their closest sword in their arsenal or whatever. I mean, it's like the first thing they're going to do. And it's so funny and it looks bad.
And that's why I thought teaching this is so important because here's the thing. Look, you're never going to know until the defense voir dire what they're going to cover, what they're going to hit. And so it's really easy to say like, oh, my last couple trials, they haven't gone after these people. They haven't gone after cause on people who hate corporations or who have sympathy and everything like that. But you have to do these things up front. We go first. We don't get the last word, in most states. And so you just have to do it because you're going to regret not doing it if the defense gets up there and does their sympathy thing and you're like, shit, I didn't do sympathy. Or they get up there and be like, how many of you have, can't be fair to our employer because you've had a bad employer before? And you're like, shit, I should have probably covered that. Sometimes you get away with it. Sometimes you don't cover it and they don't cover it and you're fine. But you just sort of have to think about these things up front. You have to be proactive. And I think you got to do them unless you have a super short voir dire, 20-minute voir dire or something.
And there are certain kinds of things that I think elicit more sympathy than others. So you have to be more aware. Like, if your plaintiff is an 80-year-old person, they're going to hit that hard. So you're going to have to be very careful about sympathy on that, for older or like a much younger person, right? Like if you have a minor, all of those things, they're going to hit really hard for sympathy. So you just have to kind of look at it from like a bird's eye view.
Right. But don't roll the dice and just assume like maybe they won't do it. You got to do it.
No.
But look, this is a super important concept because, I think judges, maybe because they haven't fully fleshed out in their minds the difference between empathy and sympathy or a compassionate person versus someone that's going to feel pity for somebody else and let that influence their verdict, because there could be times when maybe an inexperienced judge or, is going to allow the defense to get away with granting cause for someone because they are a compassionate person simply because it wasn't explained well enough the difference between sympathy and empathy, because we would hate to lose compassionate jurors. Well, obviously we want compassionate jurors for our cases, but so we got to insulate them, and this is why it's so important to do this concept not on the defensive but on offense.
And I touched on this in the very beginning, but it's clearer now. I do think your very soft-spoken, sweet, kind-hearted plaintiff jurors are the easiest walked off for cause. They are the easiest because they are so not ready or armed to push back. You know, you could picture it. You could picture it like a 22-year-old soft-spoken young woman. Maybe she's like a preschool teacher, and they're like pleasers and nice people, and they're not going to fight. So you have to give them the tools so they know that they're not the wrong person, because a lot of these people don't want to be wrong. The only time I've ever had jury duty, I was so nervous being there, and I was like 21, and the judge made it sound like a huge deal, and I started crying during voir dire because I thought that I was being told I was wrong, and that I actually truly, this is like a lesson to all of you guys who don't feel this way. I truly thought that if I said I couldn't follow the law, that I would go to jail. Just so you know, like there are jurors who feel like this in a courtroom. So it's super important to make them feel comfortable and let them know what their role is and what their job is. So that way they don't just tip over when a lawyer pushes them just a little.
Well, I think this goes back. I mean, this is a good point. I think this goes back to my original question of kind of how you introduce these concepts. And I really like how Harry ties it to the law. But I think it's important to say what you just said, Claire. It's that it's okay if you don't want to enforce the law. The bailiff's not going to arrest you. You're not going to jail. It's okay. You're not under, there's no duty right now you have to do that. And we just need to know if you are able to enforce based on the feelings and experiences you have.
Right. But I wanted to point it out because I feel like there are so many lawyers that approach voir dire like lawyers, and they don't think about how many people sitting there have literally zero idea what is going on. And I have seen a few lawyers, and I can think of one. Gary Dordick does a wonderful job in educating jurors of what they're here to do when they're in voir dire, so that they feel comfortable if they say, I can't be fair. Or I can be fair, and they don't feel like they're in a vacuum, because I think sometimes lawyers don't do a good job of informing them at all. And they feel very lost when they're being pigeonholed into these cause questions.
All right. Well, Claire, Harry, any final thoughts? This has been great. I'm sure, Claire, you are the Steve Martin of this Picking Justice podcast. So we will see you again soon.
I'm just so sad that I did not insult Harry at all in this.
There's still time.
I know. He still
was. I mean, I will point out to you that I got dressed first, and he purposely dressed in a similar color just to needle me. So I don't know. I mean, I don't know why he would do that.
Not the first time,
maybe have
and it won't be the last.
You guys frequently have the same outfit when you were going out on the night on the town?
Oh, I have definitely worn a pink dress, and he's worn a pink shirt, and it was very intentional. He went up and changed. Yeah, so no shame over here.
No shame.
That is funny. Well, the Plotkin team, this is great. We're going to be hearing a lot more from Claire. She is in trial all the time. I've had the fortune and privilege of trying cases with both of them. Very different styles, but I love it. I learned so much each time I'm with both of them. It's really great experience. You're both wonderful. Thanks for being on, Claire.
Of course.
Thanks to the Law Pods team, always making this easy and accessible, and just great people over there to work with. So thank you to Law Pods and all of our sponsors.
If you're enjoying the podcast, the best compliment you can give us is sharing it with a colleague who would find it valuable. For all the best clips from the podcast, follow us on social media. You can find those links in the show notes. Have a jury selection story to share? Email us at podcast@pickingjustice.com, and we may address it in a future episode. Until next time, remember, you're not just picking a jury, you're picking justice. Produced and powered by Law Pods.